Welcome. My name is Wanda Rochelle, and I am a licensed realtor and probate specialist serving Georgia, Florida, and Alabama. I'm so excited today and welcome everyone to my channel. I have a special guest with me today, and today we are talking about deed transfers. This is such a hot topic, and we're going to touch a little bit about how to avoid the probate process. So I want to go ahead and get started. I want to welcome attorney Mark Moss. He is a Florida attorney. If you want to go ahead and introduce yourself.
Absolutely. Thank you very much. Again, my name is Mark Moss. I am a Florida licensed attorney focused on estate planning, probate, guardianship, all around elder law.
Awesome. Thank you so much for accepting my invitation. I know that your schedule is probably busy, but I appreciate you taking time out of your schedule. So I want to go ahead and get started. Excuse me. So the first question is, if someone owns a home, what can they do to ensure they avoid probate?
Absolutely. So again, great question, great way to start it off. And I'm going to apologize. The answer is probably going to be a repetitive one that we hear throughout, but it all comes down to planning. If you want to avoid something, you need to plan to not end up there. What we see often are multiple generations that fail to plan. And then all of a sudden, someone in the family wants to stop the cycle. The only way for them to stop it is to now go through probate and try to undo what the last 2, 3, 4, 5 plus generations failed to do. So if they want to avoid it, they need to plan. And there's various ways of planning. Obviously we're talking about deed transfers and property, whether there's trusts, different types of deeds, there's various options, but at the end of the day, it all comes down to planning.
Awesome. Awesome. Let me go ahead and get to the next question. Since you mentioned the deeds, can you explain the different types of deeds?
Yep, absolutely. So there's different types of deeds, and then there's different types of how property can be held. They're often meshed together, but they're two very distinct differences. So there's different types of deeds in the sense of a quit claim deed, a warranty deed, a life estate, an enhanced life estate. Those are just the names and the types of deeds. But then how they're held, especially for this topic and probate avoidance, how they're held is arguably more important than the type of deed, meaning that you can have tenants in common, or a TIC is kind of an abbreviation. You can have joint tenancy. You can have joint tenants with or without a right of survivorship. You can have, in Florida, what's known as tenants by the entirety, and that's reserved just for married couples. Or again, there's a life estate. There's various types of deeds or ways to hold the property. If you want to keep that property from probate, you want to make sure that that deed has a right of survivorship or a contingent beneficiary upon someone's life estate ending. When their life ends, here's where the interest now goes to automatically through the deed. If there's not any of those rights of survivorship or automatic transfers in that language of the deed, then by default, it will be part of the estate and go through the probate process.
Okay, so to avoid the probate process, there should be the joint tenants in common.
So if you want to avoid probate, you want to make sure there's a right of survivorship on there.
Okay.
Tenants in common. So let's just use you and me, for example. If we own a house together as tenants in common, you and I each own 50%, and we control that 50%. So if I pass away, my 50% does not automatically go to you. My 50% goes to my estate or anything else that I have in place. And now you own 50%. You now own that with whomever I have that going to. If we own it as joint tenants with right of survivorship, when I pass, automatically my interest goes to you. It doesn't matter if I'm married, kids, whatever else I have. I want my property going to someone else in my will. The deed governs separately And because there's a right of survivorship, that is going to govern.
Awesome. Awesome. Let's see. Let's say someone has an elderly parent and that parent owns a home. What should they do to ensure they avoid the probate process? And the reason I ask this question is because I know sometimes when our loved ones end up, 80, 90, 100 or whatever, and they own a home, I've seen the adult children just place their name on the deed. Is that a good idea? Let's talk about it.
I would strongly advise against that. Just putting your name and child's name, siblings' names on the deed. Like most legal answers, I need more information to really fully give someone advice on this. So generally, blanket statement is it depends. But when you have an elderly parent and they have voiced, here's where they want the house to go, because at the end of the day, everything needs to be in line with their wishes. So if they voice, here's where they want the house to go, and maybe that child has power of attorney, they are the attorney in fact for that parent, and they have the authority to transfer property or change how property is held, then they should look at, in Florida, we have what's known as an enhanced life estate deed, or also known as a ladybird deed. With a ladybird deed, that parent still owns 100% of that property. That child essentially just becomes a beneficiary on that deed.
Okay.
So there's benefits. One, it keeps the house out of probate. It also has some tax benefits. I'm not a CPA, but I know enough to be dangerous. And the CPAs and tax professionals that clients have worked with have told me there is, there are tax benefits, and one of those major one being a step up in basis. So again, I'm not a tax professional. If I misstate this and someone's out there, please don't, come at me too hard in the comments. But, if someone for a step up in basis, let's say the parent bought the property for $200,000 and it's now worth $1 million. There's 800,000 of gains. If the child gets a step up in basis, when that parent passes, the child's basis is not 200,000. The child's basis is $1 million, and they don't have to worry about paying capital gains taxes on that 800,000 of gains. If they just put themselves on the deed right away, they then take the parent's basis of 200,000. Then when they want to sell the house, they're looking at a much, much higher capital gains tax they have to pay.
Awesome. And I'm glad you said that, because I think a lot of times people they underestimate the need to speak to an attorney, because we live in an age where people will just Google, Google things, and based off of what you just said, you now have created, an issue for yourself. So thank you for that information.
Absolutely. Yeah, the Google Law School is it's an easy one to get into, but it's a hard one to get factual information from.
Right. It gets to the point that you should have hired the attorney in the beginning, and now you Googled it, and now you need the attorney.
And it gets, it's like anything in life, you want to save money up front and Google it and do it that way. It's more expensive to go back in and pay someone to now clean it up and do it properly.
Right. You mentioned a term that I'm not familiar with, ladybird deed. So,
Yes.
so assuming someone is in this situation, they can reach out to your office to have that deed created, I'm assuming.
Absolutely. We do those all the time. And there are some huge benefits that a ladybird deed offers that other deeds and other ways to hold property don't offer.
Awesome. All right, let's see. My next question kind of goes back to what we talked about before. Um, can a tenancy in common deed be transferred to a joint tenants in common? And I'm assuming that obviously that it can be done.
It can be done. It's just a matter of making sure that you've got the right things, the people listed, the right things in place. If there's a mortgage, if there's insurance, all of that stuff, all of that is properly updated. But it's very easy and it happens often. It's usually referred to almost as a straw man deed. If my wife and I, if we bought a property before we were married, but there are certain protections that now come when you own a property with a spouse.
Mm-hmm.
We can now take a property that we owned as joint tenants with right of survivorship and now deed it from ourselves as singles to ourselves as a married couple and now get that protection.
Okay,
So it can
awesome.
be done and it's done often. It's very common.
Awesome. Explain why it is important to consider avoiding the probate process.
So I'm going to give a loaded answer to that. And one, yes, it's important. Again, going back to the very first question you asked me and my answer of it's all about planning. But
Mm-hmm.
the probate process gets a very bad rep and a bad reputation that it's scary and it takes years and years and years and you're going to lose everything. It's a very methodical process, and it's one that very often isn't a terrible thing to go through. The
Mm-hmm.
reason, though, and what you want to avoid is putting as little as possible that goes into that probate, into the estate part of that probate process. Because once you have assets in probate, those now are frozen until the court signs an order, of distribution or terminating, closing the estate, and it's subject to creditor claims. So there's certain exemptions, there's certain things that we can do in Florida that intentionally, when things go through probate, we know that they are exempt from creditors. So the fact that they are in probate isn't a big deal because they're going to end up going to the beneficiaries. It may just take a little bit longer to get there. But a big thing, if you don't plan, is the elephant in the room or the legal fees. Those can be extremely impactful, and really reduce what ends up going to friends, family, whoever the beneficiaries or heirs of the estate are. Legal fees and court costs, can cut into those very quickly.
Mm-hmm. And I'm pretty sure another factor would be COVID. I mean, how was the probate process during COVID? I'm sure that was a delay.
Slow, and there are some counties that are still dealing with some of that. There's some counties that, so when you go to do a discharge, basically the last thing we need to get signed in a formal administration to close everything out, it goes to the clerk's office and the clerk does a review, essentially an audit of the file. And they are, some counties, they're 6-7 months behind. So we file it and we're left now just twiddling our thumbs, waiting on the court. There's nothing we can do to speed it up. They have their process and their method, and we're just in the queue waiting.
Wow. Wow. Good information. Thank you.
Absolutely.
Okay, let's see. Next question is I hear the terms transfer on death or payable on death. Please define those
Yeah.
terms.
So both of those are analogous to a beneficiary. I think most people understand or familiar with a beneficiary. I have a life insurance policy. Here is who my beneficiary is. When I die, here's who it's going to pay out to. Transfer on death, pay on death, essentially are the same things. There
Mhm.
are just some accounts or types of accounts that do not allow a beneficiary designation. Um, so they function the exact same way. They just don't call them that. POD or pay on death is generally used more for like bank accounts. So if you're checking your savings, if you call and ask for a beneficiary on that account, 9 times out of 10, they're going to tell you, sorry, we don't offer that, or we can't do that. If you call them and ask for a POD, no problem. Here's the form. You fill it out, put it in the file, and it's just like a beneficiary. TOD is more for other types of investments that don't have or allow a beneficiary designation. But again, at the end of the day, It's just a different word for the same thing as a beneficiary.
Okay, awesome. This is good information. Please share the video, everyone, um if you want to educate others, because this is good information.
Better than that Google Law School.
I was just about to say that. I was just about to say that. Okay, if someone does not have a copy of their deed, what do you suggest they do, and can it be located online? And I'm asking this question because I realize that as a realtor who specializes in probate, sometimes that loved one does not have a copy of their of the person's deed.
Yeah, and this is going to be very state dependent. Sometimes even within the state of Florida, because we serve all 67 counties in the state of Florida, sometimes even counties are different in their process, but generally speaking, these can be found, printed, obtained online.
Okay.
Um, some counties only go back a certain number of years. Um, Duval County, which is where my office is located in, I believe they go back into the 80s, and I could be wrong, but generally that's kind of where I find that they're no longer available online. And at that point, either you have to go to the courthouse, or sometimes we can contact them and see if they can't send it to us. But
Hmm.
they have records, you can get them. Most of the time, again, you can get them online. Otherwise, you might have to go to the courthouse. Some counties, some states may require you to pay a small fee. And if they do, you're talking $5, $10. It's a very nominal fee. But I tell all of my clients, when we record a deed here, if they're putting it into a trust, if we're doing a ladybird deed, any type of real estate deed that we're doing, they will get, not if, but when, they will get a letter in the mail that looks very official, and asking them to pay somewhere between $150 and $175 for a certified copy of the deed. I tell all of my clients not to pay it. It's not legitimate. If you look at the bottom of that letter or the back of it, in very small print, it tells you that it is not affiliated with the county. You can go online to get it. And all of my clients, when we return, their executed life plans back to them,
Hmm.
there's a copy of that deed with the recording right there on it. So they have it in their possession.
Hmm. So I'm glad you pointed that out, because though that is a scam, that's a scam all day long.
And it looks very official. And I have
Mhm.
clients insisting that it's real. And look, send it to me, and I will tell you exactly where it shows, and says that it's not. And we show them, we tell them the last thing we want is someone getting scammed, out of that money. But it's not affiliated with the county. You don't need to pay that much money for it. If the county charges between 20 and $25 a deed, they're not going to charge you 150 for another
Wow,
copy.
exactly.
The numbers just don't match.
Scam. I know you discussed Florida, but what states do you serve, and what specific services do you offer?
Absolutely. So we're in Florida and Georgia. And again, anything, if it falls within the broad elder law umbrella, we likely handle it. So anything from, putting plans in place. Most people think of it as estate planning. We call it life planning here, because
Mhm.
everyone needs it. Some people don't think they have, a sprawling estate, but everyone has a life. Everyone has assets that they want to protect. So from that to trust or estate administration or litigation, guardianships, guardian advocacy, supplemental needs trusts, long-term care, Medicaid planning. We assist with all of that in the states of Florida or Georgia.
Awesome, awesome. And I'm going to go ahead and put your website on the screen for everyone, as well as it'll be in the description area of this video. Um, let's see. I want to ask, what documents are needed to transfer a deed?
Absolutely. So if we're drafting a deed, the first thing we're going to need is either the existing deed, because we need that legal description, or we have to go, as we talked about, to the clerk, courthouse, to get a copy of that for that legal description.
Hmm.
Draft the new deed. When a client comes in to sign the deed, their identification. ID is the only document we need to look at for the notary. But the most important thing, we talked about if there's an older parent, sibling, someone else that we're transferring this deed for, we need to make sure that the person, the grantor, or the person transferring the property has their capacity. If they lack capacity, they do not have the ability to sign into these. So it doesn't matter how many forms of ID someone brings, what they told you, me, spouse, children, what they told anyone a week ago, a month ago, 10 years ago. If they don't have their capacity at the time of the signing, they can't sign it. If they do, we need an ID and then we're good to go.
So what's the definition of capacity?
Medically and legally, they differ. I'm thinking of the best way to answer that, because there's legal capacity to sign a will, which is a different legal capacity to sign other documents. But generally speaking, they have to understand and know what they're doing, not be under the influence of drugs, alcohol, medication, anything that's going to influence that decision. And the other thing that goes into it's not a direct capacity concern, but another one is, are they showing up with someone else? Are they being forced to do this? Is this someone else's will that's being exercised on them? Undue influence, is someone forcing them to do something? Those are all kind of red flags.
Right. And I'm sure that this is real, or we wouldn't need to say it. I can just say myself, I remember one time I had a client pass away, and his brother was going to be handling his estate, and his brother located a will, and it didn't have a signature. His brother asked me if I would sign the will. So I was just, shocked, so it's real. We want to, make sure we're operating in integrity.
Oh, it happens all the time. I had one, if we're to compare, war stories here, that one of the beneficiaries photoshopped the will and changed the distribution percentages. The distribution percentages and what they amended exceeded 100%. So the numbers didn't match up, and the footers of the documents also did not match up.
Wow.
So it was a very poorly done job, but goes to your point that these are not just made up things. These happen more often than we want to think about.
Right, right. So if you're watching this and you're considering doing something that's not legal, not right, reconsider, because jail is real.
Jail is real, and I'm told it's not fun.
Yeah. Actually, I'm actually a volunteer in the Department of Corrections. So yeah, jail is real. Mm-hmm. All right. Next question is, what's the difference between a deed and the mortgage?
Absolutely. So again, another very good question, and a legit concern impact. There's very real differences, especially when it comes to does this need to go through probate or not. So the deed, which is often thought of kind of as the title, is who owns the property and how is it held. That goes back to the tenants in common, tenants by the entirety, joint tenants, right of survivorship. Who owns that property? The mortgage is who is borrowing and who is obligated to pay for that property.
Mm-hmm.
And they don't have to be the same thing. And when you think about a property and does need to go through probate or not, the mortgage is not relevant entirely to doesn't need to go through probate. The mortgage is relevant as a creditor against that property.
Mm-hmm.
But if, let's say, again, going back to, the two of us are married,
mm-hmm.
and we own property together, and both of us are on the deed, but you are the only one on the mortgage. Because
why can't you be the only one on the mortgage instead of me? Why can't be the man?
Well, because I'm going to die in this example, unless you want to. I was going to be chivalrous and not kill you off. So if I die, no, let me flip that. I'm on the mortgage, not you. And
Thank you.
I die. The property doesn't have to go through probate because you still own that. There's a right of survivorship and how we held that deed.
Mm-hmm.
You, though, have to figure out a way, either refi, there's something you have to do with that mortgage.
Right.
But it's not going to require probate for that.
Right.
So can be differences of who's on the mortgage versus who's on the deed and the title. Two very different things. Both need to be considered as part of that planning process.
Mm-hmm. Now, let's say in that example, I'm grieving and I'm just not dealing with any mail that's coming to my house. They're calling me saying the mortgage is late, Wanda. It's now 4 or 5 months behind. Let's talk about that because that's real.
That is very, very, very real. The mortgage is very, very likely to be a secured interest. What that means is you pledge to pay X amount each month to let them borrow for the mortgage. If you don't pay it, they can foreclose and take it. Just like on a car, they can repossess it.
Right.
So if you are late, they can now start the process of foreclosure.
Mm-hmm.
As part of the probate process, we would notify the mortgage holder of my passing, and here's what they need to do if they want to file a claim to get paid back. And at the same time too, that also notifies them, and they have kind of form letters they send out of, either you can assume the mortgage or you need to refinance it. There's different options you have, but the hypothetical you brought up is a very real one. So
Mm-hmm.
It's very important, especially or specifically for secured creditors, continue making those payments.
Mm-hmm.
The grieving obviously is very real. The best thing I would suggest, put those payments on auto pay so you don't have to think about it.
Mm-hmm.
So they're getting done.
So does the mortgage company have to comply with the probate, or is it their decision? I guess my question is, can they say, no, we're going to foreclose next week? Or does it depend on the mortgage company?
It's going to depend on the mortgage company, and there's a whole foreclosure process and a timeline they have to go through. I have a couple estates that we're handling that they are dealing with foreclosures. We don't handle foreclosures.
Mm-hmm.
We just stay involved, because we represent the estate, and from that perspective. But every time I've discussed anything with the judge in the foreclosure matter, there have been extensions. It's not a definite. It's not always going to happen. In these specific instances, the judge, gave extensions. There was leniency, understanding that, the probate process is not an overnight thing and it takes some time.
Mm-hmm.
There's one that, we're looking at here, and I have a counsel coming up. There are over 40 different heirs. It's going to take a lot of time to notify everyone, get in contact, and the mortgage company wants to get, this debt off their books. I understand that, but we've got all these different heirs we have to deal with, and the judges understand that, so they have some leniency for that. But obviously, if you have the ability or the means, continue making those mortgage payments. That's where, again, I don't sell it, but the importance of life insurance, and other things like that come into play, because while someone's grieving, maybe they're not, going back to work.
True.
There's some income, and money that's come in to help offset some of those expenses.
That's so true. That's so true. That's a good point. I love it. Love it. Let's see. I just want to remind everyone to click the link in the description area, because I do have a private Facebook group where we talk about all things probate. Okay, so here's a question that I received via email. from a young lady. The question is, do I need an attorney for a summary probate? And what is a summary probate?
So I'm going to answer those in the reverse order.
Hmm.
So summary administration in the state of Florida is one that is available. So there's a couple different levels of probate in Florida. Summary administration is right in the middle. That is available if someone has been deceased for 2 years or more,
Okay.
or if the value of the estate is less than $75,000.
Hmm.
That $75,000 threshold excludes exempt property and excludes the homestead. So if there's the primary residence and a bank account with 20 grand in it would be eligible for summary administration because it's under that 75 because we exclude the house. Or again, if someone has been deceased for 2 years or more, it doesn't matter what the value of the estate is, it's eligible for summary administration. And that 2 year threshold is there because that's how long creditors have to file a claim against the estate if they were not notified. So that's kind of what summary is. And it's a less formal process. There is no personal representative that is appointed. They are just known as a petitioner. They don't have the same rights or authority as a personal representative, which could be good or bad, depending on the need or how you look at it. As far as is an attorney necessary? That's a loaded question. Take it with a grain of salt. What I do for a living. That's almost like one of me asking you, do I need a realtor to sell my house?
Absolutely.
So you should, and you do. The statutes, legally speaking, it's not required to have an attorney for a summary administration. The statutes require an attorney for a formal administration, but we always recommend, an attorney for summary because there could be creditors. There are still things that are unknown to that grieving family member that we deal with on a regular basis, that we know what to look out for, what to watch out for, that they may not. So statutorily, is it required to have an attorney? No. But again, it's what we do for a living. So take it with a grain of salt. We always recommend it. But we try to be very upfront, with potential clients when we're talking to them during that consultation. Yes, we think you need one. We don't really think you need to even go through probate. But if you want to, here's what we can do, and leave it up to the client. We take a very educational approach, and want to show you, here's all the trees in the forest. Here's the one that we're going to focus on. Do you want to chop that one down and attack it, or leave it alone and let the clients decide?
Awesome. And even when I received this question, I think it's important to note that we don't know the details of we don't know the whole picture.
Right.
We don't know how many heirs there may be, so this kind of is just a general answer.
Right. And I will say too, everything I just said was specific to Florida. If it's Georgia, if it's other states, everyone has a different process. I'm not licensed in Georgia. There's another attorney in my office that is, so I can't even discuss, the Georgia nuances.
Right. Awesome. Okay. This same person asks, can the probate process be done electronically in Florida?
Yes, to a certain extent. And again, each county has some nuances. But especially since, post-COVID, few courts and specifically the probate departments are going back in person. Others are keeping it on Zoom just for efficiency. And the majority, even if they're in person, will allow an electronic appearance. But if the client, does the client need to show up? No, that's what they've hired us for. We are appearing on their behalf in their capacity as personal representative or petitioner in a summary administration. But 99% of it can be done electronically, depending again on the level of probate. There may be some documents that we need with a wet signature and notarized, but the majority can be signed and done electronically.
Awesome. 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 Well, that was my last question. Just based off of everything that we've discussed, is it something that you want to add?
Not specifically. I think just generally, this is a topic that few people like to think about, but it impacts everyone. I've yet to meet someone that's figured out how to prolong and keep living. There's a few things that are certain in life, death being one of them.
Right.
So we know it's going to happen. We don't like to think about it. The best thing we can do, the best gift we can leave our family, the best gift we can give to ourselves is having a plan and ensuring that it's a proper plan and that it's going to work when we need it to. Again, it's not like, applying for a credit card and, oh, that's the wrong credit card. I made a mistake. Let me redo this or apply for one later. When we need to do these things, someone is either incapacitated or has passed away. There's no redos. So it's all about planning. Even if it's as small as, do I put myself on the deed or do I do a ladybird deed or look at something else? Those are not small decisions. The example we talked about was an $800,000 difference in, taxes.
Mhm.
So biggest thing I would say is just plan, and go and talk with a trusted professional. Don't trust, or don't leave it to Google. Don't leave it to the, $50 do-it-yourself things. The $50 do-it-yourself things, as many different attorneys as I talk with, we all kind of look at that as job security because I've yet to see any of those actually work properly.
Mhm.
Not to say that I'm sure some people are going to comment and say that theirs did, and I'm just an attorney trying to take people's money. I've seen it all. I've heard it all. Personally,
Yeah.
the attorneys I've talked with, we've never seen one of those work properly. But I'm sure there's some out there that might.
Excuse me. I'm glad that you referenced it as a gift because it hurts my heart, and I'm sure you to see some of the things that happen when people don't prepare for their death by doing the life plan. Excuse me, as you call it. So with that, with it being a gift, I just want to challenge anybody that's watching this. You may watch this whenever, but it's September right now. And as a gift to your family by Christmas, I'll give you plenty of time. Even though time is not promised, I just want to encourage you to just, take the necessary steps to ensure that your affairs are in order. If you don't have a will or a trust or any type of life plan in place, be sure to make that one of your goals. And so, like he said, as a gift, do it for Christmas, even though that gives you plenty of time. If you're needing services in Georgia or Florida, I have Attorney Moss's information here on the screen, his phone number, the office number, as well as his email, and I will have it in the contact area of this video. So I want to thank you, Attorney Moss, for taking time out of your schedule for joining me today. Again, everyone, my name is Wanda Rochelle, and I am a licensed realtor serving Georgia, Florida, and Alabama. And if you need my service in any of those areas, or even if you need services in any of the other areas, I do partner with um, realtors across the country. So we thank you for joining us. Have an amazing day and please share the video.